Let's head back to Georgia now for more of day 3 of the dismembered wife murder trial for defendant Mindi Kassotis. Prosecutors say that Kassotis killed and dismembered his wife Mindi back in 2022. The defense is pointing the finger at a mystery man, saying that he, Jim McIntyre, was controlling the movements of the couple somehow. Let's go back into the courtroom. DNA analyst on the stand. Let's watch.
I'm going to turn it just so that the jury can see as well. Counselor, you need to reposition by all means. Are there notes on here as to the exhibits?
Yes. When evidence is submitted to the lab, we need the evidence item to be identified with the agency case number, and contents of the item.
And would you be able to determine if this was the same exhibit that you tested, being a black or a gray tote, by looking at all of the markings on this exhibit?
Yes.
And are they, in fact, and I'm pointing to 1.5, and now additionally to 1.6?
Yes, these are the items that I tested.
Okay, and in the form of testing, you referenced a swab, is that correct?
Correct.
And did you swab these specific totes?
Yes.
I'm going to pull out 1.5. Would it be fair to say that this is the black tote?
Yes.
And the other box then, is that the gray tote?
Yes.
Okay. And when you swabbed it, can you tell the jury exactly what you would physically do to go about doing that?
So in this case, I took out the item, I examined the item for the presence of any of that observed reddish-brown staining, which I did see. I then took a swabbing of that staining, tested it for blood using those 2 chemicals. It indicated the presence of blood. It had also been requested that there be contact DNA testing performed, as well as latent print examinations. So I swabbed the handles of the tote, trying to get the general palm area where somebody's might be pressed up against it, while avoiding any areas that latent prints might find useful.
Okay. Is there a possibility of problems if you go out of sequence in terms of who tests what first?
Yes.
So is there a preferred procedure, meaning DNA first or fingerprint first?
Serological examination, so any of your biological fluids are tested prior to sending it to latent prints.
And why would that be?
Some of the chemicals and testing that latent prints uses in their examinations can interfere with our testing.
And is that the procedure that was followed here?
Yes.
Do you see that latent print? I mean, I know you don't do latent print analysis, but do you see that latent print dust on the exterior of this exhibit?
Yes, that's what that would appear to be.
That was not present when you did your testing, correct?
Correct.
So that would have come subsequent to your analysis?
Correct.
Okay, I thank you. Now, you can have a seat. I'm gonna try and put this back. Just so we're clear, there had been some prior testimony rather, that there's some different tape that's used by the crime laboratory than, for example, this red evidence tape. Which tape is your tape?
My tape is this red evidence tape you can see right here on the side with my initials right there.
Okay, so that would have been you reclosing this box after you completed?
Correct.
And do other divisions of the crime laboratory use different types of tape?
Yes, as that tape says impressions evidence on it, I would presume it was from the latents.
Okay, so different parts of the laboratory use different material tapes so that they can document that, is that right?
Yes.
Okay. Now, without sounding perhaps like a silly question, if there was blood in your swabbing from inside of the tote, that was from the inside that you swabbed or the exterior?
The inside.
Did you swab the exterior?
The exterior, the handles were swabbed for contact DNA.
But any of the other portions on the exterior of the tote were not swabbed?
Correct.
Why not?
I didn't observe blood on the outside of the tote.
If you had seen a reddish-brown stain on the exterior, would you have also swabbed that?
Yes.
Okay. So in this case, would it be fair to say you swabbed the areas that you made an observation of what could potentially be a biological fluid?
Correct.
Okay. And you indicated both the gray and the black tote had swabbings that revealed blood?
Correct.
Okay. Now, in addition to the totes, you referenced some clothing items. Can you tell us, with respect to those clothing items, I'm going to show you, I believe it's, if I may, Your Honor, I will have to go behind the witness. I'm handing the witness 1.15. Do you recognize that exhibit?
Yes, State's Exhibit 1.15 is the clothing items that I tested in this case.
And would it be fair to say that those are the items that are on your report as 36A, B, C, and D?
Correct.
Okay. And did you process those similarly to how you just described?
Yes.
And those are the same items themselves here in the courtroom today?
Yes.
Thank you. Now, if there was a lid of a container that did not come into contact physically with, for example, in this case, the issue is the portion of somebody's human remains, how would DNA deposit on a substance? Can you explain that for the jury?
DNA can deposit on a substance either through contact DNA, skin cells, or through the biological fluid. So a biological fluid would have to come in contact with the item.
So if there was no physical contact.
All right, we're going to get a break first. Jack Rice, does the defendant have to take the stand in this case? He's an attorney, but he's got a wild story about this Jim McIntyre. Unless you have phone records or surveillance video of a guy named Jim, how else do you tell this bizarro story to a jury other than put your guy up?
Yeah, if he doesn't take the stand, I don't see how you can continue with Jim. You need somebody to be able to introduce it, to talk about what it means. Otherwise, it falls flat. And remember, one of the things about credibility is not just the credibility of witnesses. During opening statements, when a prosecutor or a defense attorney says, this is the evidence you're going to see, if you don't produce it during the trial, a jury can very easily start to dismiss everything that you say, and that can be used against the defendant. And so this is a risk from the defense to make this argument.
There has to be something to, like, there's got to be a little bit there, right? Or is this out of the blue? I mean, it had to have come from the defendant as well.
Yeah, there's no question. In fact, usually what we call this is an alternate perpetrator. And depending upon the jurisdiction, with alternate perpetrators, you basically have to come in with sufficient evidence that the court would actually provide what we call a JIG, a jury instruction to the jury about a possible alternate perpetrator. But what happens is if there's no evidence that's ultimately presented at trial itself, it's very possible the judge themselves may refuse to provide that JIG, that jury instruction, to the jury that says there was one because nothing was presented. You can't just say, it wasn't me, it was the man behind door number 3 if there was no doors 1, 2, or 3. You have to be able to present something rather than just randomly start pulling things out of the dark.
Yeah, the Jim McIntyre defense needs a little something, not just blurting out his name in the opening statement. So we'll see as it progresses.
Not even that. It's Jim McIntyre or whatever his name might be. So it's actually sort of worse.